Welcome back to the courtroom, where justice, drama, and raw emotion collide. Today, we're diving into the case of Chris Frost, a man standing before the judge with everything on the line. At first glance, Chris looks like just another defendant, a father of two, a caretaker for his ill mother, and a man struggling with health issues of his own. But beneath the surface lies a history riddled with substance abuse, criminal charges, and a plea deal that caps his punishment at 10 years in prison. This hearing is about more than guilt. It's about mercy, redemption, and whether Chris deserves a second chance. We'll see defense arguments highlighting his family ties, his role as a caretaker, and his recent epilepsy diagnosis. On the other side, the prosecution will hammer his past and a shocking drug possession charge involving not one, not two, but 11 bags of cocaine. As this case unfolds, ask yourself, should Chris be granted probation to care for his family and treat his medical condition? Or is his criminal past too heavy to ignore? Stick around, because the twists and emotional stakes in this hearing are jaw-dropping, and by the end, you'll have a verdict of your own in mind.
According to your plea bargain agreement, punishment is to be assessed at a cap of 10 years in the prison. There's a $1,500 fine. The state is opposed to your application, and they're taking in consideration 2023 CR 4342. Have both parties had a chance to review the PSI report state? Defense?
Yes, Judge.
Any objections to the PSI report state?
No, Your Honor.
Defense?
No,
All right. Any witnesses state?
no, Your Honor.
Defense?
Just my client.
All right. Could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right. You can lower your hand. State your name for the record, please.
Mr. Frog, what's time?
All right. Defense?
Thank you. Chris, how old are you?
35.
And how many children do you have?
2.
Are you close to them?
Yes, ma'am. Yes, sir.
How old are they?
12 and 15.
Do you don't have a formalized child support arrangement, is that correct?
No, sir.
But you give approximately $700 a month?
Yes. Oh, like every week, pretty much.
But you're not going to do $700 a week.
No, pretty much like in a month. Or whenever they ask me for money, I try to help them wherever they can.
But you told me it's approximately
Yeah,
$150.
about 150 a week.
I need you to wait for me to finish
Okay.
because this lady's taking everything down, so we can't talk at this. So approximately 150 to 200 a week.
Yes. Yes, ma'am. Yes, sir. Sorry about that.
And then you also are living with your mother right now. Is that correct?
Yes, sir.
Does your mother have health problems?
Yes, sir.
What sort of health problems does she have?
She has like heart conditions, high blood pressure, all kinds of stuff. She goes to the doctor a lot.
Are you the one that takes her to the doctor?
Yes, sir.
And is that at least twice a month?
Yes, sir.
And in the PSI, there's some mention that you have some brothers that maybe live there sometimes, but they're not currently taking care of your mom.
This is a powerful moment. Notice how the defense leans into Chris's role as a caretaker, highlighting his mother's heart condition and how he's the one taking her to the doctor twice a month. This paints him not just as a defendant, but as a son who shoulders responsibility. Judges pay close attention to this type of testimony because it's not just about Chris, it's about the ripple effects of his sentence on his family. What do you think, though? Should someone's role as a family caregiver reduce the weight of their criminal past, or should the law remain firm regardless?
Are they?
No, sir.
And in fact, they're not living with her currently.
No, sir.
Now, you also have a girlfriend.
Yes.
What's her name?
Jennifer Lyons.
And Jennifer has been coming to court every time, correct?
Yes.
But
Yes.
where is she today?
She's at work.
Where does she work?
She's
And she's had that job for several years.
4.5 years now.
Now, she's obviously very supportive of you. Is that correct?
Yes, sir.
And every single time I've ever seen you in court, she's here with you. Is that correct?
Yes, sir.
But unfortunately, she couldn't be here today.
Not today. It was your last week.
Now, you work as well.
Yes, sir.
What do you do?
I do HVAC and I cut hair.
HVAC and cut hair. So I want to talk about the HVAC work in particular because you also have some health problems of your own. Is that correct?
Yes, sir.
And it's something that we've informed the court of in the past with regard to these seizures you've been having.
Yes, sir.
And you finally were diagnosed with epilepsy. Is that correct?
Yes, sir.
Did you have a seizure today,
Yes, sir.
this morning?
Yes, sir.
And you have these seizures how often?
Pretty much every day.
And you've been seeing a neurologist
Yes, sir.
and they've prescribed you medication.
Several. Yes.
Has it been helping at all?
Here's where things get very human and very serious. Chris reveals he has daily seizures and was diagnosed with epilepsy. Think about that. Daily seizures while trying to work HVAC jobs, cut hair, and raise kids. The defense is smartly using this medical angle to show that prison may not just be harsh, it could actually be dangerous without proper treatment. But here's the problem. Prison healthcare is notoriously unreliable. Do you think Chris should be sent to a facility that may not manage his condition properly, or is that just part of the price when crimes are committed?
Sometimes, but that they don't. They're still trying to pinpoint like I won't have like no seizures at all, but they're trying several medications still.
And I'll explain to the court a little bit about the epilepsy if the court's unfamiliar, but that's very scary, isn't it?
It's just,
Having these seizures.
it's,
Sometimes it happens in the shower
that's where it first started.
and you'll collapse to the ground sort of thing, right? And have you hit your head?
Yes, sir.
Now, with regard to doing HVAC, you're not giving up in attics, are you?
No, sir.
Oh, especially not with your health condition.
Yes,
You're doing everything
on ground level.
at ground level, okay. And you work for a friend or a relative?
It's just me and a buddy. We're starting our own HVAC company.
And is that full time?
Yes.
So you're working at least 5 days a week, and I would imagine this summer is going to be good business for you.
Yes. It's starting to pick up.
Now, Chris, we have to address the elephant in the room, which is your past, your criminal history. And as you know, it's sometimes difficult for judges to consider putting someone on probation who's been in trouble in the past, right?
Yes.
How old were you when you first got arrested? Back in 2007, I think. So 17 years ago. How old are you? 17, 18. All right.
18.
And when you went to prison back in 2016, I'm sorry. So that was 8 years ago. Is that correct?
That's it.
You haven't been to prison since then, correct? And in fact, you had been you hadn't been in trouble in several years, is that correct?
That's it.
Until this most recent arrest.
Yes, sir.
Was this a wake-up call for you?
Yes, sir.
Do you
And here comes the elephant in the room, the criminal history. Chris admits he's been in and out of trouble since he was just 17. This is where things get tricky for the judge. On one hand, nearly 2 decades of repeated offenses suggest a cycle he hasn't broken. On the other, Chris insists this most recent arrest was a wake-up call. The courtroom tension spikes here. Is he truly ready to change, or is this just another chapter in a long pattern? Viewers, what do you think? Should past mistakes always outweigh present intentions?
I've discussed with you the pre-sentence investigation and how they're recommending that you get treatment. Do you understand that?
That's it.
And you can understand looking at your criminal history, which is mainly drug related,
Yes.
where a judge would say, hey, maybe Mr. Acosta needs some sort of drug treatment. Do you understand that?
Yes, sir.
Are you willing to take drug treatment as a condition of probation?
Yes, sir.
The only concern for you, of course, is that you need to continue getting treatment for your epilepsy. Is that right?
Yes, sir.
So would it be fair to say that we're asking the judge to consider your application for probation and consider placing you in outpatient treatment first, see how you do that in that? And then if you slip up there, then you would be more than willing to go to inpatient?
Yes, sir.
Do you think you can abide by the rules of the court?
Yes, sir.
Do you think that you can stay clean from drugs and alcohol?
Yes.
Is there anything else you'd like to tell the judge about your situation or your family or anything? Are you sorry to be here?
Yes.
Are you embarrassed to be here?
Yes, sir.
Has this been hard on your family?
Yes, sir.
Is this causing your children a lot of stress?
Yes, sir. I'm not gonna.
Your mom
Yes, sir.
and your girlfriend,
Yes, sir.
right? She's very stressed out every time you guys are here. Is that right?
Yes, sir.
But everyone is supporting you. They're helping you get the medical treatment you need and things like that, right?
Yes, sir.
Okay. Okay, Judge, I have nothing further for my client. The prosecutor may ask you some questions.
Yes, thank you, Judge. Sir, when you were stopped at this DWI, you had controlled substance on you, is that correct?
Yes, that's what they say. I don't remember. That's what they say. Yeah.
When you had 11 bags of cocaine.
Yeah. Well, I don't.
Whoa. Stop right there. This is the bombshell moment. The prosecution lays it out plain. 11 bags of cocaine, 2 bags of heroin, and pills. This isn't just recreational use. This screams distribution-level possession. Notice Chris's response. He claims he doesn't remember, blames it on partying during the Super Bowl, and even says, "That's what they say." This kind of denial undercuts his credibility big time. Now imagine you're the judge. You hear the defense argue epilepsy, caregiving, family stress, and then you hear about 11 bags of cocaine. Which side is weighing heavier on your scale of justice right now?
Recall.
Okay, well, I mean, to be fair, that's what the
Yeah.
and then also 2 bags of heroin,
Yeah.
and also like 5 Adderall.
That's good.
Was that the first whole list?
The Adderall, I don't remember how I got the Adderall. I mean, there was a day of partying and so like it was during the Super Bowl, so I really don't remember it much. I just remember the cops waking me up and they pulled out whatever, I guess. And I mean, really pretty much I woke up in the top car.
I mean, I'm just saying 11 bags of cocaine and 2 bags of heroin and 5 Adderall. This seems like quite a bit of drugs carrying on.
Yes, I understand that.
And then also with your previous convictions and of your felonies, you did get offered and you did take deferred adjudication or probation on those, and then you weren't able to successfully take those. Is that right?
Years ago? Yes, sir.
And then also as late as in 2016, that's when you got your conviction. You were actually on probation for 1 to 4 grams, and then you were sentenced in 2016 because you picked up another 4 to 200. So you aware of that?
No, it was on probation.
Okay, you weren't on probation at all. So you took 5 years. Okay. No further question, John.
All right, any follow-up?
No further questions. Mr. Argument.
All right, court will hear argument.
I'll go ahead and go first.
Yeah.
Sure.
Maybe you want to last. Judge, I mean, just moving this, it's criminal past. This was initial, the state did waive that enhancement to allow him to apply and substantially lower the amount of time that he would be facing if he was facing the habitual status. So to go to that, Your Honor, including the DWI, including with the possession of drugs at that time, state request and TBC.
Thank you, Judge. We understand how difficult the situation that Chris put himself in back a couple of years ago. This was not a wise move on his part. But when I see his criminal history and I see the facts of this offense, I see someone that is struggling with a substance issue or substance issues. In talking to his girlfriend, she has told me the same, that she feels like he could use some treatment. You know, we're dealing with a 35-year-old man here, Judge. Yes, he's a grown man. He's an adult, but he's been in and out of the system since he was a teenager. And when you look at that history, it doesn't look like he was ever given the opportunity for treatment as far as I can see. And at this stage in his life, he does want treatment. He wants to better himself. He wants to get his business off the ground. He wants to continue taking care of his children and paying for them the way he's supposed to. This is... sending him to prison is the natural instinct, I'm sure, for a court. But in this circumstance, we would ask that you consider placing him on probation and giving him the treatment that he needs. I have a personal concern with the epilepsy. As someone who has an epileptic in my family, I know how serious this is. And I lost an uncle who collapsed and fell and hit his head in his own kitchen and died. So my concern is that if he goes off to the jail and then to the prison, that he won't get any sort of medical treatment that is necessary. And one of the things that's interesting about epilepsy is that your body is continuously adjusting to the medication. So what works today might not work 6 months from now or 3 months from now even. And you really have to be on top of it with a neurologist. who has to monitor you constantly to make sure that the medications that you're on are the appropriate ones that are helping you.
This is the defense's most emotional pitch yet. Notice how Chris's attorney gets personal, even mentioning a family member lost to epilepsy. It's a clever strategy, humanizing Chris by connecting him to the lawyer's own life experience. The attorney also emphasizes that prison won't provide consistent medical care and pushes for probation plus treatment instead. It's a bold appeal to the judge's compassion. But will it work, or will Chris's drug record overshadow every sympathetic detail? Viewers, if you were on the bench, would you risk probation on someone with this history?
He has been doing better. The seizures are not as severe as they were, say, 6 months ago when we first informed the court of this issue. But he still is having them. It feels like his doctors are slowly narrowing down. But one of the issues is he doesn't have health care, so he has to pay out of pocket, and neurologist visits are very expensive. But he is able to do it when he can. Again, my fear personally is that he gets to the jail, he gets to the prison, and as we know, the medical treatment in either of those facilities is not the best in the world. So based on all that you have in front of you, Judge, we would ask that you give him that chance on probation. Let him try to prove to you that he's not the person he was in the past, that he will not have violations in front of you any further, and that he can be the person that he should be.
All right, Mr. Costa, I want to let you know that I listened to the arguments of your attorney, internalized everything. I understand people have medical issues, and I understand that sometimes if people look back over their life and they could do things differently, they would do things differently. I just don't think you're a good candidate for probation, so I'm not going to grant your application. As previously stated, I'm finding you guilty. Does anyone want to speak in regards to the cap? It's a cap of 10.
They've asked for 10. I would obviously ask for the minimum too, Judge. I think that would be, the least amount of time that he's away from his family, away from his mother, away from his children, and away from his doctors too, would be appreciated.
All right, this is what the court will do. Court is taking in consideration 2023 CR 4342. There's a 50.
And there it is. The gavel comes down hard. Despite the defense's heartfelt pleas, the judge denies probation and sentences Chris to 8 years in prison, with a $2,500 fine and a 2-year license suspension. She acknowledges his medicals, struggles, but ultimately his past criminal record and the severity of the drug charges outweigh any argument for leniency. This case reminds us that in the eyes of the court, personal struggles don't erase repeated offenses. Chris's story is heartbreaking. A father, a caretaker, a man with epilepsy, but also a man caught with a staggering amount of drugs. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
$1,500 fine, time and money were run concurrent. Court will give you credit for any time served. There should be a 2-year license suspension. I'll request the therapeutic community for you, but I have no control on whether or not they place you in the therapeutic community. You'll have to ask for it also, but they'll see it in the judgment that I am requesting the therapeutic community, and I'll sentence you to 8 years in the prison. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. All right, good luck to you.
Thank you.